ಯಾರು ಜಾಯ್ನ್ ಆಗಿಲ್ಲ ಇನ್ನು.
देश बेचने वाले एक हो सकते हैं तो देश बचाने वाले क्यों नहीं एक हो सकते। जब चमचा, कटोरिया, थरिया और बिना पेंदे के लोटे एक हो सकते।
ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ ಹಿಂದೆರವರಲ್ಲ.
My lord, High Court mic is muted, my lord.
We are not able to hear anything.
Mic is muted, my lord. High Court. Yes.
Now it is unmuted.
Yes,
Now you
yes.
are very well. Give memos. Yes. Yes. You give memos. Give memos. Yes, yes, Kumar. Give tomorrow. Tomorrow will be the urgency. Give memo. Give memo. Next. That was not relating to the regularization. Fine. Yes. Particular. Yes, better. Yes. Or petition, sir. Next. Request him.
No, serial number 7.
List after 2 weeks.
Supreme Court has rejected the transfer petitions. We need to file some additional documents.
Serial number 1 in list number 2, sir. Labor matters.
I'm sorry, Lord.
Labor matters. Yes. 2 weeks.
I am asking for respondent number 5 in
After
case
2 weeks. Yes. Next week, next week. ಬೇರೆ ಕೊಡ್ತದ ನಮ್ಮ ಕೊಡ್ತದ ಈ ಕೊಡ್ತಲ್ಲ ಬೇರೆ ಕೊಡ್ತು 1 ಡೇಟ್ ಕೊಡಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೂರನೇ ಸೋಮವಾರ ಅಥವಾ ಮಂಗಳವಾರ ಈ ಕೊಡ್ತಲ್ಲ ಅದು ಬೇರೆ ಕೊಟ್ಕೊ ಎಸ್
Serial number 7 in B group.
Serial number 4, so B group may not be taken up, sir.
We want 2 weeks time, Lord.
Yes, 2 weeks in all the matters it will be given.
My lord, serial number 8, interim order has to be extended, my lord.
Wherever the interim order is there, it will be extended.
Please, my lord.
Much obliged.
Yes. I think it has to go to the Harvard bench.
serial number 15.
It has to go before the Harvard bench, actually. Yes. You see, the impugned order is passed. The impugned order is passed by the employee EPF so and so Bellary, Annexure A. Just go before the Harvard bench. And the respondent is also is from Hubballi. Just then, all the take for an example. Though you have a head office in State Bank of India in Bangalore, but it has to go before the Harvard bench. Told him. In this matter, in this writ petition, the petitioner bank has challenged order dated 30th 3/2023 passed by the respondent number 1, regional PF commissioner -Roman 2, employees provident fund organization, Bellary. The respondent number 2, employee hails from Hubballi town, Hubballi city. In that way of the matter, the registry is directed to transmit the petition to the Harvard bench. Yes. Notice, issue notice to the respondents. In addition to this, when a counsel appearing for the petition is permitted to serve copy of the petition to the panel council of the respondent corporation. Same order? Yes. From 7 to 15, it will be next week. Sorry, 2 weeks.
2 weeks because one file additional done
2 weeks.
statement.
2 weeks. 10, huh? 10 on the next week.
15 will go there.
Yes.
Stay may be extended. Malad. Just
Yes, yes. Wherever the stay is granted, it will be extended.
Much obliged.
Serial number 9. Date.
I am party in person, my lord.
Yes, sir. 4, sir. 4. Yes. 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 It has to be hard. Next week it may be taken up for good wishes. Yes, sir. Yes. We will be taken up in B group next week. It's a 2020 matter. B group it will be listed.
Your Lordship, serial number 15, final hearing.
Be taken up in next week in B group. No. Let it be next Monday, Tuesday. It may be taken. Yes, I know. Incompetent authority. Yes. Tuesday. Yes. Memo is accepted. The petition is dismissed as not passed.
Lordship, list number 2.
I will copy to the other side. Affidavit shown to competent authority. 2 weeks. 2 weeks. Huh? Yes. Then it will become in big. So then a counsel appearing for the petitioner submitted that the petitioner is not pressing IA 1 of 23. Accordingly, IA 23 is dismissed. With this matter in B group next week one date.
Your Lordship, proceed.
Complaint of office objection along with counsel submission. Yes. Sir. Yes. Better copy of file it. Better copy. Page number. Better copy you can file page number 8 and 9. Better it requires complaints within 2 weeks. Complaints. The counsel appearing for the petition submitted that complaints will be made within 1 week. Is this matter in the preliminary immediately after complaints of the office? You complain immediately. 2 weeks. 2 weeks time to take. When a counsel appearing for the petitioner submitted that needful has been done. Let us will. Sir, then. Sir, you have to fill up book. This Anganwadi is. Yes, sir. Yes. Yes, sir. Sunday would be restaurant. Just Anganwadi worker, Ajji Salisaga. Where is that? Page 21. Page 21. Yes, sir. 61. Page 16. Yes, sir. What? Patiya Marana. So have you, only thing is, have you uploaded the death certificate of your? You're right. In all respects, you're right. What is required is Vidivayadali Patiya, the death certificate of the husband. No, that we don't in rules. That may be true actually. See, what will happen? What will happen? You may produce a second PU exam. You may produce the second PUC pass result. That does not mean that you have rejected that you cannot. Maybe. No, only thing is what is required, sir? 31, sir. Yes. 31, sir. Annexure E, sir. Yes. 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 Yes, sir. Yes.
I think there is the eligibility. This is not like I would have got 2000 but experienced like that. Not done it.
You say that. Check for, even if a master degree holder, check for even for a master degree holder, the SLC marks card is very important. You are right. That cannot be. Yes. Yes. Yes, sir. Both are widow, but in your case, that it cannot be considered at all. Yes. Yes. Yes, sir. The only thing is, it said no. The selection, the notification, say that a requirement of the death. Yes. The ends of justice will be met if the authorities are directed to reconsider. No, now the objection cannot be considered because you're not uploaded. No, you're not uploaded the requisite. The thing is, the item number 7 in the notification.
below. That's the date of filing the application. I had my university mind and that's my hand.
You challenge the notification. You challenge the notification. You challenge the notification. You challenge the notification. In the meanwhile, let us.
My interpretations are not used. Not if I went in this case, your own that my another before possible. But the revision bench. It's all before the day.
Yes.
Because of
Ah.
even if you have not made the decision,
Where is that? It may be a relevant date. Yes, sir.
but it's there that depending on the time for school. What has been given an approximate. Further, we made that even at the rural level, qualification of the book standard cannot be accepted to focus on computer knowledge, and therefore the respondent in the mind would even otherwise an eligible candidate and was more meritorious if he can't get that. Peculiar circumstances in this case, taking into account of the respondent in the mind, the candidate is more meritorious candidate than the other. We are inclined to the all the chapter.
The peculiar facts.
Two Buddhas were there. If they feel not we talk about then they will not find the basis for us.
But
In this case,
the Honorable Supreme Court said that what is uploaded that you have to do.
and we have to big format and dedicate and pay. That should be considered. And the technical none of them for this case, the general of the committee, after taking remand this matter back to the country. Because my representatives are not.
Yes, sir. 57. Sir. Next year. R9. Yes, sir.
Yes, sir.
Yes, sir.
All the way handling program.
57, sir. One minute. Yes, sir.
Serial number 4. Which is color right? You want to be on operation.
Yes.
I have filed various I find a representation of 69. So, not funny. Not funny.
Good. Though the matter is listed for orders, please run, please. The matter was taken up for final disposal at the consent of the parties. Please run. In this writ petition, petitioner is assailing the proceedings dated 9/9/2022 passed by the respondent committee within bracket annexure G, inter alia sought for consideration of the case of the petitioner for the post of Anganwadi helper in which center, sir? In Kaulaveli, Gaudara, Atti village, Village, Challakere Taluk, Chitradurga. The relevant facts for adjudication of this writ petition are that the petitioner and the eighth respondent have filed application pursuant to precedence, pursuant to the notification issued by the respondent authorities for the post of Anganwadi helper of Alivehalli, Gaudrahatti, Challakere Taluk, Chitradurga. The respondent authorities, having considered the documents produced by the parties and other applicants, has issued have issued the notification dated 9/9/2022, selecting the eighth respondent to the said post. Feeling good by the same, the petitioner has approached this court. I heard Sri Venkatesh H. Venkatesh Doderi and a counsel appearing for the petitioner, so and so and AGA for the respondent. Sri Venkatesh Doderi and a counsel appearing for the petitioner contended that though the petitioner had produced the widow certificate dated 16/7/2022, produced at annexure C to the writ petition. However, not considering the same, the respondent authorities have selected the eighth respondent herein and accordingly sought for interference of this court. In this regard, he refers to the judgment order dated 3rd January 2023, passed by the division bench of this court in writ appeal number 1240 of 2021, particularly he refers to the paragraph 4 of the said order. Per contra, Mr. Nagraj, MS Nagraj and counsel GGA invited the attention of the court to the requirement of the death certificate of the husband of the widows in the event if they are made an application for the said post. And as the petition herein has not produced the death certificate of her husband, and accordingly, the same was not considered as the same is contrary to the notification dated 16/6/2020. In the light of the submission made by the Lana Council appearing for the parties, on careful examination of the notification dated 16/6/2022, the applicants have to furnish the relevant documents as mentioned in the said notification produced at annexure A. Item number 7 reads as under page 16. Page 16 ಅಲ್ಲಿ ವಿಧಿವಿಯಾದಲ್ಲಿ ಪತಿಯ ಮರಣ ಪುತ್ರ ಒಂದೇ ಒಂದು ಲೈನ್ reads as under. Having taken note of the factual aspects on record that the petition herein has not produced the death certificate of her husband, accordingly the respondent authorities have not considered the case of the petitioner, and same is reflected in the provisional list issued by the respondent authorities. In view of the judgment rendered by the Honorable Supreme Court in the case of so and so, reported in so and so 2022, wherein it is clearly stated that it is the duty of the applicant to furnish the relevant documents as mentioned in the notification calling a notification issued by the respondent authorities calling for fill up the relevant post in that way of the matter, comma, though the petition herein has basis reliance on a judgment of the division bench of division of this court referred to above. On careful examination of the paragraph 4 would indicate that the division bench, having taken note of the merit as well as the peculiar circumstances of the case thereunder, comma, has dismissed the appeal preferred by the rival claimant. However, the Honorable Supreme Court in the aforementioned case has stated that it is the obligation on the part of the applicant to furnish the entire documents what is sought for in the notification. In that way of the matter, comma, I find force. I do not find any merit in the writ petition accordingly rejected. Yes. Yes, sir. Yes. Ah, yes. Which Karnataka state sees this judgment. Two weeks' time is granted to take necessary steps. Retirement filed by. So. Yes. This is relating to 371G. Testing.
Only the document verification, the name is there. And I not find any right. Do not.
Just to be heard. Just to be heard. Yes, sir. You can file an objection and run a council appeal. I know. I will consider memo of retirement filed by sponsor. Memo of retirement filed by Srimati Lata S. Shetty is accepted and permitted to retire from case. Since she says Satish K is representing on behalf of the petition. So registry is directed to delete the name of Lata S. Shetty from the cause list. So there are two. One is amendment. Another two are the impleading applications. What about the amendments? What about the amendment? Objection to amendment. What about the impleading application? You can file objection. No, file it and it will be considered. Come on. Even otherwise for assisting the court. Even otherwise also. See, whenever they.
Every party no order in the first. Other party they register, but the question now is not. Only question is who committed.
Such strict rule will be only CPC matters. It's 226 and 227, where we need the assistance from. That's all. Let it be, do one thing. Let it be allow them to be a part of the. They will assist the court. May not come in the way. Take for an example, in the event if the writ petition is allowed, take for an example, then the impleading application will be dismissed. Maximum. That's why let they will assist it. Let they will assist. That's why what I'm saying, take for example, impleading application, only they will assist us. That's all, nothing much. It may be.
still cannot be that. No other variety.
No, instead of next week, it could be done today. It's one stage, it will be over.
They can't cover according to them. But next week,
I don't know.
there are some semblance of right. There.
So what you're saying that a legal rate is not accrued for them unless they have been notified by virtue of a note
At least next week is
selected
there.
list.
Yes.
But they will assist us at least.
On the legislature, it's very clear, right? You cannot change.
Yes, that's correct. That's on merits. That's on merits. That's on merits.
And the voting.
So do one thing. I will impeding application will be allowed. That they will file objection to the main petition. In the meanwhile, I think someone would like to file objection to IF 5 of 23 for amendment. So
And the Lord-
I will fix.
On application.
Do one thing within 15 days. I will fix up a date. 15 days or something else. Because now many matters are there. Right? So it could be taken up.
Then all government also prepare.
Yes, that's right. Very well. What serious objections? Anyway, that is subject to the result of the petition. No? Not now. That is only after the disposal of the petition. That's only after the disposal of the petition. Not now. Yes, yes. Very well. I got heard. Told you. Heard the Lana Council. You filed it? No. Heard the Lana Council applying for the parties. Parties on IF 5 of 23, 6 of 23, and 7 of 23. Full stop. Having taken out the factual aspects on record, and after hearing the Lana Senior Council, Sri MS Bhagwat Pas, Sri Satish K, and Mr. Sondi, Senior Council on. So your for Sri Parshuram Ajjampur appearing for the impleading applicant on AS 7 of 2023. I'm going to review that, the IA 5 of 23, 6 of 23, and 7 of 23 are required to be allowed. And a council appealing for the petitioner is permitted to amend the petition and to file the amended petition accordingly. So in the meanwhile, it is open for the contesting respondents to file statement of objections. And 15 days could be one dinner take over. So same order in next matter, IA 3 of 23 and 4 of 23. 11th. 11th at 2:30. Yes. It is allowed. No, nothing. It will be allowed anyway. Both IA 3 of 23 and 4 of 23. Including amendment. That's why interim order granted earlier, extended till next step. So with an understanding that will be taken up 11. Yes. Needful done. Then a council appealing for the petitioner submitted that needful is done. Register is directed to verify this. Interim order again. Interim order granted earlier, extended till next. Notice subjection non-service. No, that is process. Even though sometimes.
They can't take it over. That's the reason I subjected. It's not that I can.
You serve copy. They serve copies once. For Union of India, Leonard AGA. Sorry, Leonard AGA accept notice for. I think notice is already ordered, sir. Not order. You serve copy to the ASG better.
It is not that because I this both cover the other.
Really?
Their food was covered in the other expeditions.
So far as this very union government is there, normally they will be served ASG. You serve one copy, sir. You serve copy to the other side. ESC can serve this office objection. Then a council appealing for the petitioner is permitted to serve copy of the writ petition to the ASG. Yes.
Only he is appearing in all the
You sir, let us come in, be a preliminary. You sir, even government is also party, sir. You sir, copy to the government also. Sir, you sir, then a council appealing for the petitioner is permitted to serve copy. Yes. You sir, copy letters. You serve it and move it any day. Preliminary any day. So you move it today, tomorrow it will be taken. Yes, sir. Yes, what is next matter, sir? Annexure B. Annexure B, sir. On what ground that you challenge? Uh-huh. Huh. 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 How discriminatory? Huh. Correct. Elderly person should be given even in life also. We have to respect them. We have to respect the elderly people. Maybe that cannot. Non-compliance office objection. What is a non-compliance? Yes. Office objection is overruled for time being. What is wrong with this order, sir? Yes. Issue notice. Let AG accept notice for respondents. No, that cannot be used. That cannot be used. Yes. Directions. When it has to be heard, the statement of objection filed by GS. Third topic. Learned AG is permitted to remove the office objection within 1 week. Within 1 week? Within 1 week. Yes. Let us will. Attendance register. That's an attendance register. Yes. Yes. Yes, sir. Yes. It's not an appealable order, sir. It's not an appealable order. What your challenge is annexure L. Annexure L is challenge. It is issued by the institution. Aided institution. That's why under Karnataka Education Act, they have a remedy. Karnataka. You see, it is passed by the college. Any person or governing council agreed by an order passed by an officer or authority that this act within its jurisdiction. So appeal insofar as the authority is concerned. Now it is by the institution. State government may either suo motu or an application from any person interested call for an exam in the record of an education institution or any authority officer person. 131 you can file. 131, please read. No, what to say? Please read. No, yes, one pass over. 131 that you can approach. It's an order passed by the institution. Can go before the authority. Yes, sir. So that is on merits. Let we will examine. Please see the Karnataka education. 131. You can approach the union government, sorry, the state government. Yes, pass over. Good evening. Ultimately they can consider your representation. Whether it could be taken up in a B group. B group. Yavat. 230 bit. Regular. 230 we have. Yes. 230. Yes. It will read. So list this matter on Yavat 15th. List this matter on 15th in B group. B group, sir. 15th Saturday, na? Change ಮಾಡಿ. 14th or 17th. Any day of your choice, both of you. ತೊಂದ್ರೆ ಇಲ್ಲ. Monday ತಗೋಣ. 17th. Yes. Interim order granted earlier, extended till next term. Yes, sir. What your challenge, sir? 20. So you are seeking consideration of qualification so and so from 1989 to 95. What were you doing for all these things? Writ petition is 22. Consideration is of the so and so 95. From 89 to 95. What were you doing from 95 to 2023? Maybe true, sir. No cover. That cannot be considered. So, no, sir. What were you doing from? So for 95 to 2022. For 27 years, you are not approached. But earlier you approach. Where is that? That is 2019. Even take for an example 2019, 95 to 2019, what were you doing? What were you doing so far, sir? Yes, sir. Yes, Mr. Government. 247A. Yes. Two 47 of KCS, sir. But what about from 95 to 2019, sir? That's what. That cannot be done. 89 to 95, what were you doing? No, sir. Even they don't have even records also relating to 89 to 95. That's a different thing, but he retired in 2018. But now you are seeking for a past period from 89 to 2009. I will dispose of saying that subject to the result of the return. But you have to establish that in this writ petition, petitioner is selling order dated 14/5/2020 within bracket annexure D. Please sit down. Issued by the respondent, respondent number 2, seeking relief under Rule 247 of the KCS, Karnataka Civil Services. Heard the runner counsel appearing for the parties. It is the case of the petitioner that petitioner was working as assistant teacher at Sri Vishwabharati High School, Mallasandra, Tumpur Taluk from 1989. It is the case of the petitioner that, that the appointment of the petitioner was confirmed by the respondent number 1, respondent authorities from 8/6/1995 in terms of the memorandum of dated 12/6/1995. It is also noted that the petitioner has attained superannuation on 31/7/2018. In the meanwhile, the proposal to sanction the pensionary benefits has been sent to the respondent government, and the same was not considered in terms of provisions provision under Rule 247-A of the KCS. Accordingly, the petitioner has approached the respondent authorities, and the respondent authorities, by impugned notification dated 14/5/2020, Annexure D, rejected the claim made by the petitioner. Hence, the petitioner has presented this petition. I heard so and so for the petitioner and so and so under AGA for the respondent. On careful examination of the writ papers would indicate that the claim made by the petitioner with regard to the fact that he has rendered service in the said institution from 19/1/1989 to 8/6/1995, that is for a period of 6 years, 11 months, 18 days, and the said period has to be considered as a qualifying service in addition to the actual service rendered by the petitioner as per Rule 247-A of the KCS. In this regard, in this regard, on careful consideration of the order dated 5th July 2018 in WP number 25814 of 2017, within bracket Annexure C, I am of view that, the petitioner is entitled for the benefit under Rule 247-A of the KCS. However, then at AGA is submitted that the matter is pending consideration before the division bench in writ appeal number 2476 of 2015. And accordingly, I am of view that the petitioner is entitled for the relief comma, based on the outcome of the order that may be passed by the division bench in writ appeal number 2476 of 2015. With this observation, writ petition is disposed. Yes. Notice. When a DG accept notice for respondent number 1, 2, 3, issue emergent notice to 4 and 5. This was civil post. This is AG. Rates for the civil post. Annexure E. Select KT. Just approach the KT. Heard the Lana council appeal for the parties. Mailgade. The so AG accept notice for respondent authorities. Then AG raise primary objection relating to the maintainability of the petition on the ground that the petitioner is having an alternative remedy before the Karnataka State Administrative Tribunal. In that way of the matter, taking into consideration the fact that the petitioner is seeking relief insofar as the civil post is concerned, the petition is the writ petitioner is relegated to approach the Karnataka State Administrative Tribunal. Hence, the writ petition is with this observation, writ petition disposed of with liberty to approach the tribunal accordingly. Yes. Notice. The AG accept notice for respondent number 1, issue emergent notice to 2.
Serial number 90.
Single post. Yes, Mr. AG. Just to be allowed. Just to be allowed, actually. Just to be allowed. Yes. Then AG accept notice for respondents. Third, the Lana council appeal for the parties. The grievance of the petitioner in the present writ petition that the respondents have to be directed to fill up the post of lecturer in economics without reserving the post for the category as there is a solitary post. In that way of the matter, following the declaration of law made by the Honorable Supreme Court in the case R.R. Inamdar versus State of Karnataka and others, reported in 2020, 19 SCC 54343. I am of the opinion that the respondent authorities are directed to inform the respective institution to appoint the single post appoint the post of lecturer in economics, if it is a single post and same cannot be reserved in terms of the judgment rendered by the Honorable Supreme Court in the above case. Accordingly, writ petition is allowed. Notice, madam. Issue emergent notice. Notice. Issue emergent notice. Let AG accept notice for respondent number 1. Issue emergent notice to 2 to 4. Yes, Mr. Prashant. What is the post? What is the nature of post, sir? What is the nature of, yes, first. This retiring, right? Yes, sir. Yes, sir, very well.
He has an intent. He takes it to another authority.
To whom that you made an,
Command he makes.
you have to make it to the appointing authority.
That has also been considered.
Then, yes, sir.
Maybe he made a mistake. But I we take notes of doing general. And not as application.
That is also been served on him.
Even otherwise, it has to be considered. They may reject it. They may reject it also.
His contention is that he makes an application now and he would like to retire in January. After he gets his increment being made to him.
Yeah.
That is one point here.
Next year is a even year, that's why even. 2024, even year. Not in a order year.
That is one aspect is one of the ground that is application for voluntary retirement is building. On the ground, he is not.
From which place to which place, sir? At Bangalore to,
South zone itself, it is home zone only.
if you say that they have passed an order malifiedly, then it may be interfered. Since how long you are in this? In this?
Minimum for a period of 3 years, I have been. There are people not who are staying here more than 3 years. Within 10 months, I'm not have a contract time.
They are blessed. They are blessed. They are all blessed by the God. But you are not blessed.
In 2010, he is in the South zone home sector.
Yes, sir?
2010, and I just issued by the commandant and certified.
Yes.
Paragraph number 4.
From 2010, from 2010 he is in Arakonam, Bengaluru. I think you were there in the Bangalore. From 2015 to 2021. 6 years were there here.
7 months.
And thereafter, Mahendra Giri.
Also South zone.
Then, Prashant, unless it is a malified in nature, I can interpret.
They take order. Or I directed not to get. It is not, normally not all transfers work.
Yes, sir.
Minimum for a period of 3 years, I should be kept. 10 months, that too not out of time.
But you were there, no? From 18/6/2015 to 31/3/2021, you were in Bangalore. Again in Mahendra Giri, 21, 1 year, less than 1 year, sir, 4 months only. Then again in Infosys, Bangalore, 1922 till date.
And I just go about page 19.
Till date means earlier also you were in Bangalore.
The 3-4 months not I get retired.
Better get retirement in a peacefully. Another place, not with these people. You're not happy with them. Unless it is a malified, that I cannot.
Also not I made a dedication.
Yes.
This is fine. It was not malified.
Wait, how?
Page 18.
19, sir. Yes. The annual transfer order shall normally be issued by 31st March. Yes.
It's not, for a minimum set of 3 years, not I should be kept there. That is also there now. It's not follow anything. But within 10 months, page 25, page 25.
25.
Area of posting in unit transition.
25.
Unit transition.
Hmm.
In 10 months, on a request not I made transfer to Bangalore.
Earlier you were there more than for 6 years.
12 years, 7 months, 11 days is what I'm doing.
12 years? 12 years?
12 years, 7 days,
7 months.
7 months, 11 days. If your lordship, if the paper has just given, the second D, on the second sheet, your lordship will find that.
So 12 years, 7 months and 11 days. An unfortunate 11 days. Then I know, I see. Time would indicate malafide on the part of the respondents.
Which includes and she here, don't have been.
20 years. But other way not before. And transfer.
It's very limited under 226. Very limited.
Very arbitrary. Within 48 hours.
Even for climate order, 48 hours is very important. Rain will come or not. That's why. See,
Only not industrial security.
that's how I've seen this. I know. Mr. Chandrachud, please answer. Entered appearance on behalf of all the respondents. Entered appearance for the respondents. Heard the learner counsel appearing for the parties. Please answer. In this writ petition, petitioner is challenging order dated 22/6/2023 within bracket annexure A, passed by the second respondent, transferring the petitioner from Bangalore to Kudankulam, Kudankulam within bracket Tamil Nadu. Close the bracket. Having a full stop. Sri Prashant H.S. Lana counsel appearing for the petitioner contended that the impugned order dated 22/6/2023 annexure A is in violation of the guidelines produced is violation of the circular number 22 of 2017 within bracket annexure E, wherein the guidelines have been issued insofar as the transfer of CISF personnel in various sectors of CISF. It further contended that, within a period of 10 months, of his earlier transfer, the petitioner has been transferred and accordingly sought for the interference of this court. Per contra, Mr. V. Chandrachud, Lana counsel appearing for the respondent, submitted that the petitioner was working in Bangalore for more than for a period of 12 years, 7 months, 11 days. And in this regard, he produced the relevant service records pertaining to the petitioner and submitted that the petitioner was working in Bangalore since 18/6/2015 to 31/3/2021. And thereafter, he was sent to Mahendra Giri from 1/4/21 to 31/8/2022. Again, the petitioner was transferred to Bangalore and was working at Infosys Bangalore from 1/9/2022 onwards. Accordingly, Sri Chandrachud submitted that he was working in the southern sector itself for a considerable period, and accordingly submitted that the writ petition deserved to be dismissed. Having heard the Lana counsel appearing for the parties, I have carefully considered the factual aspects as narrated by the petitioner. Having taken note of the service records produced by the Lana counsel appearing for the respondent, it reflects that the petitioner was working in Bangalore from 18/6/2015 to 31/3/2021, nearly for a period of 6 years. And thereafter, he was sent to Mahendra Giri from 1/4/2021 to 31/8/2022. And thereafter, the petitioner was retransferred to Bangalore and is working at Infosys Bangalore from 1/9/2022. Taking into consideration the factual aspects that the petitioner has not made out a case for interference by alleging malifieds against the respondent's hearing, and therefore I'm of the view that the scope of interference by this court under Article 226 of the Constitution of India, insofar as the transfer matter is limited, accordingly the writ petition is rejected. Yes. Yes. Yes, sir. Yes, that will be considered. You can see that is not the, it's only transfer. That's all. Nothing. That is not given a wrong authority. Now you can give it to the particular authority to notice. Sir. Notice. Urgency, I will issue notice. That's all. Can issue notice. That's all. Then next week. Passover. Yes. But it is a society. D, sir. But there's a bylaws in so far conduct rules is also there. Even if you take it the central services conduct rules, you can't supposed to approach CAT.
I'm not against civil post. It's a civil post. It's not. I'm entitled to be a director of a cooperative society. I'm entitled to be a director.
Where is the exemption insofar as?
PC.
Yes.
I have produced the rules. It's the rule number 3. Page number 31 number.
31, sir. Yes, sir. Take part.
Not involving the political cooperative society. Substantially for the benefit of cooperative cooperative. In the mother, you have the cooperative society.
Yes. Now, how far you affected by 1906 Annexure G?
Repetition is right. They failed to get an interim order there. I just point out the interim order not there. It's in law, page number 55.
Yes.
Directing respondents 4 to 7 not to continue in the respective working levels of respondent. In the earlier repetition.
Yes.
The interim order is not granted in the law.
Correct. 56 D1.
Yes. Now, the very same thing is participated for the management. Management is design. Other than initiate the disciplinary action against you. The matter is seized by this court.
This court.
Is not granted. Achieved through the management. They say you resign. Others than it is disciplinary action against you.
Yes. So, issue emergent notice to the respondents. In the meanwhile, stay of stay of the operation of the order dated 19/6/2023, passed by the second respondent, within bracket Annexure G, till next date of hearing. Yes. Yes, sir. Also next week, let us. Yes, sir. Next week. Yes, which also. Then I will take it up now. To say urgency, I will take it up now because number of B group matters are there. Next week, let us. Next week. Yeah, afternoon 6 matters are there, it may not be taken. Yeah, I know. No, next Monday we will take it. Next Monday or Tuesday. What 13 is? No, nothing. Next fourth, next Tuesday. At the request made by the Lana Council appearing for the parties, this next Tuesday. Registries MB Shankaregowda ತೆಗೆದುಬಿಡಬಹುದಲ್ಲ You are there. You are also along with Vijay Kumar, sir. Along with you. Then it is say that NOC. 26. Yes. Yes. Yes.
My lord, I am appearing for respondent 4 to 9, my lord. I may
Yes,
be
sir.
permitted to do it, my lord, through
I am for
online, my lord. I am
Yes,
a
yes.
little unwell, my lord. I'll do it online, my lord.
I am for
Yes, sir, very
respondent
well, very
number one submission, my lords.
Very,
I am
very
for
well.
respondent number 2, my
Very
lords. My senior is not in station, my lords.
Let us
If he is permitted to put forth his arguments next week, my lords.
very, very well. Very well.
Oblige,
Yes,
oblige.
Yes, madam. What is the matter? First, the condition number 2 and 3 of OM dated annexure G. What is annexure G? Page 19, 99. That is 2 and 2020. Mysuru Vidya KS. One minute. Now one 9. Now you have been yes. What's the fact set? Yes. Yes. Assistant professor in the very same medical college. Yes. Assistant professor. Yes. Professor. Yes. For a period of 3 years. From which period? 1/8/2011 to 31/7. Just for a period of 3 years. Nephrology. Yes. 24/11/2009. Purpose of professor. Yes. Correct. 4 years or 3 years? 3 years. That means 24/11/2012 she will get. Hmm. Yes. 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 Yes.
CH-21.
91. 91. Yes. 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 She has been sent to the Department of Nephrology. Yes. 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 Next year, J, madam. 19. So subject to certain conditions you have been. Page 19. They refer to this proceedings. For item number. Yes. That is nephrology ವಿಭಾಗದ ಸಹ ಪ್ರಾಧ್ಯಾಪಕರ ಹುದ್ದೆಗೆ 3 ವರ್ಷ DM ಪದವಿ ಪಡೆದ ನಂತರ. ನಂತರ means after 3 years or yes. Yes. We are saying that a lien. 19. Correct. That's correct. How far you agreed by annexure? Past only the past. Yes. Yes. Yes, DPC is a BLE. DPC is a BLE. Yes. So it was approved on 3/11/2015 by DPC in the DPC, but not given effect to. Yes. 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 Order sheet. Order sheet you are referring. Just one. Those who have been promoted, they were earlier to the nephrology department, or they came after? What 18, 12, 20? To produce the original records pertaining to the promotion to petition. Yes. Yes. 31. Yeah. They are supposed to produce.
I don't have, I don't have. Always.
Yes. Where you got these documents in? Where? College or the state government? Now that means the original records are with them. College. 29. Still to comply with. Yes. Yes. Memo is present. Yes. Page 3. Yes. Page 8. So out of 12, see, from 2 to 10 were promoted. Even for 11 and 12 say that it requires another 8 minutes. For insofar as the 11 and 12 is concerned, it stated that the 8 months is required. DPC approved, but official order not yet. Even during 2014 itself, it is approved. Yes. 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 Where is that one? Page number 16. Department wise, designation wise, also working. Page 22. 16 and 17. So far as yours is concerned, serial number 16 and 17 is has been remained vacant. Yes. This is by the government. That they will produce this. That the government will produce this. Respondent will produce. Do one thing. According to, I think it is written by the director then. That's what you want. Page 3. Yes. Yes. We don't ask for existence. We don't. That will direct the institution to produce the record. I will make it a pattern that they will produce. That they will produce. Or the Lana Council appearing for him. Are the Lana Council appearing for the parties in part? This court by order dated 18/12/2020, directed the second respondent and the state government to produce the original records pertaining to the promotion of the petition. On 31/3/2022, this court has noted that the proceedings of the DPC meeting held on 3/11/2015 and the 3/11/2003 has to be produced before this court. However, such record has not been produced before this court till date. In the meanwhile, the petitioner has the relevant records from the second respondent RTI. The second respondent is directed, shall produce the original records pertaining to the DPC meeting held on 3/11/2015, particularly with reference to the petitioner is concerned by next date of law, failing which the who is the head of the failing which the director of the second respondent number 2 shall present before a court. Yes. Is this matter on when respondent that they will produce. Friday it may be taken up. 30th. Let they will produce.
Your Lordship, kindly next week, Your Lordship. Senior is not available here.
No, just only to produce the records.
Next week, Your Lordship, kindly, Your Lordship. We
It's
have
26.
to take an instruction from our senior Lordship. Hence.
No. You have to.
It appears Mr. Gowda is out of town, my lord.
26th, sir. 26th Monday we will take.
My lord, your lordship may have it on next Tuesday.
Oh,
my
that's
lord.
sorry.
That is on 4th.
That is on 4th. Let them.
Yes, Your Lordship. Much obliged.
My lord, I have one submission, my lord.
Yes, sir.
My lord, this petitioner was not at all entitled to the post of lectureship as assistant professor, associate professor, and professor.
Let us let them produce. Let us.
My lord, the
Okay.
government, the document.
Let this matter and so for further hearing.
Please, my lord.
For further hearing. Yes, ma'am. After preliminary. After preliminary, it will be taken.
Lord, serial number 27. I seek a short accommodation, my lord. It may be taken up next week.
Request made by the Lana Council appealing for the petition. Just after 2 weeks.
The date may be given, my lord.
2 weeks. 2 weeks. Yes.
Obligation.
Yes, yes, Mr. Chair. Yes, sir. Next week. At the request, your person? Your person? At the request made by the Lana Council appealing for the response number 6 in WP number 23474 of 2018. Next week. R6, sir. R6. Okay, okay. Go. Oh, next in R6 in 5554 of 2020. Let us please. 4. Yes. Yes. What is the matter? Yes. Good. We'll take it up next week. At the request made by the council appealing for the parties just next week. Yes. Also, argue, I will take it up. No Passover. Argue, I will take it up. Or else next week. Yes. Yes, sir. Oh, that is also. Just a way. Can it be connected with that then? Let us. Let's next week. Yes. Let's next week at the request made by the Lana Council appeal for the petition. Yes. Next Tuesday. A list on so on at the request made by. Yes. Yes, sir. Yes, Mr. Chandrasekhar, what's the matter? What is the matter? Request made. Yes, yes. Can it be Passover or next week? No representation on behalf of the petitioner. Then a council appealing for the response number 6 is present. List next Tuesday. Yes. What your channel? Give promotion as assistant engineer. Sort for quashing annexure L. So, ಕಾಮಗಾರಿ ನಿರೀಕ್ಷಕರು ಹಿರಿಯ ಕಾಮಗಾರಿ ಅಲ್ಲ ಕಾಮಗಾರಿ ನಿರೀಕ್ಷಕರಿಗೆ ಕಾಮಗಾರಿ ಇದೆಯಾ ವರ್ಕ್ ಇದ್ರೆ ಮಾಡಿದ್ರೆ ಅದೇ ವರ್ಕ್ ಮಾಡಿದ್ರೆ then you will inspect. Yes, sir. Yes, sir. Page 17. 17 page. In BBMP. Yes, sir. Ward number 73 so కట్టడం వాణిజ్యం చాలా yes yes So complaint against Prasanna Kumar. Complaint against Prasanna Kumar.
We plan and we have the authority to enter. It is in charge of the in charge of
ಎಲ್ಲ ವ್ಯಾಪ್ತಿಗೆ ಬರುವುದಿಲ್ಲ yes yes charges so memo of charges is there yes
statement filed by the delinquent number 3.
yes you're not attended the proceedings they're not attended the proceedings saying that you know yes no power is vested in DGU yes yes she's so and so we say that there's illegal construction say that illegal construction yes even in the complaint also is stated that ನಿರಂತರ yes
In this manner, there is no specific
Yes. Yes, sir. So 2011ರಿಂದ 16ರವರೆಗೆ as on the date of the complaint, page number 16, you are working there. You are working there. Thereafter, you are. Yes. Yes. That you denied it. Yes. Yes. What happened in inquiry report?
Here.
Yes, sir. Yes. Yes. ವರ್ಕ್ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಆಗಿ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದರು.
It is only sentence basing upon this.
That's the only finding. Now charges have been proved. So notice.
He went to the DDA. That is a pure holiday.
Annexure K, it's a second show cause notice. No, after inquiry report, the second show cause notice was issued as per Annexure K. It's according to Annexure K that you are not received. Yes, yes, sir. Yes, sir, government. Inquiry report is not received. Straight away pass Annexure L. Yes, ma'am. Have you served the inquiry report to the petition? Who has to, I think, government. Yes, sir. And whether the inquiry report and the Annexure K was issued to the petitioner? When? Tomorrow. Next week it is in front of our High Court only. Can get it by 2:30. Or the Lana Council are paying for it. According to you are not received. Or the Lana Council are paying for the parties in part. Is this matter for further hearing on Friday? Friday. Good. Regular. Look into it. Dispose this. Yes, sir. Yes, we'll see. No. Unigopal, yes. Turn again. 2 weeks. An appointment. Finally, 2 weeks. Date. The request made by the Leonard Council appearing for the respondent number 3 to file 3 to 7 to file statement of objection. 15 days. List on. By that time you can file it. Yes. What is this? Yes, sir. Yes. What type of settlement? Yes, sir. Who pay for the institution? At the request. Yes, sir. At the request made by the Lana Council appearing for the petitioner that there is a likelihood of settlement between the petitioner as well as the respondent institution. List after 2 weeks. Interim order granted earlier, extended till next week. 2 weeks. Let us wish. Finally, by 2 weeks, sir, it will be taken up. Yes. What is this matters? You have a petitioner. What your challenge? Which order that your challenge? No possible. Next week. At the request made by the petitioner, list next week. Yes. Yes, sir. Yes. Let's take a look. You are ready? Ready with the man. Just let us switch. What is challenge, sir? EAT. Yes. What's the matter? Yes, sir. Yes. Physical education teacher. 19? Correct. Sir. Page number 93. Yes. Anyway, the name of the petition was recommended by the institution. Correct. Sir. G1, page 70. Yes, sir. Yes, sir. Yes. $70. So according to them that you have not secured the degree from the competent university. Yes, next. Yes, which page? 74. Yes, sir. So it addressed by the institution. Then what has happened? Yes. J6. 78, sir. 78. Yes. Correct. Correct, correct. But you're not regularized. Not at even as on today, you're not regularized. But then how can you approach the EAT? Now, how can you approach the EAT then? And so for a temporary employee cannot approach. Where is that regular appointment? Where is the regular appointment? Sir, just show me the relevant document saying that you have been appointed regularly. No, you show me. Not necessary. So far, according to even yourself, your appointment is not regularized. That's why they are notified for the appointment. As per the news item that now, then you cannot approach the. Sir, you have not been appointed regularly. Then how can you approach the EAT? You show me the appointment you regularized. Where is that? Where is that? No, where is that? You show me that you have been taken in granting aid.
Based on recommendation from granting.
But it has to be approved. Unless if it is approved by as and that you are a temporary employee, then how can you approach EAT? How can you approach EAT then? Third is, you can take answer. Huh. Even otherwise, the EAT has no jurisdiction. Yes, sir. You had approached secretary then. Then what has happened before the secretary? Correct. But of course, you cannot challenge the order passed in the EAT. But what your challenge is the order passed by the EAT. Correct. Even the EAT has no jurisdiction. Third. You can withdraw and no, I don't. There's no jurisdiction at all. When EAT has no jurisdiction at all, how can I set aside this order? You're a temporary employee only. Then one more repetition. That's all. You can withdraw with liberty to approach a competent authority. No. Otherwise, third, the Lena Council applying for reports. Yes, that could be done. That third, the Lena Council applying for reports. In this petition, the petitioner is challenging order dated 13th April 2022 precedence passed by the Educational Appellate Tribunal and in the Court of Principal District and Session Judge at Mysuru, dismissing the appeal. Having taken note of the arguments advanced by the Lena Council applying for the parties, the petitioner has not produced any record to establish that he has been appointed and his appointment has been approved by the competent authority in terms of granting aid. Accordingly, any of the provisions contained under section 92 and 94 of the Karnataka Education Act 1983, the aforementioned tribunal has no jurisdiction to entertain the appeal under section 94 of the Karnataka Education Act. In that way of the matter, I'm not sure that as the tribunal has no jurisdiction to pass any order under 92 and 94, section 92 and 94 of the Act, the petition is deserves to be dismissed. However, it is open for the petitioner to approach a competent authority if so advised. Yes. With this observation, the petition is disposed. Yes, sir. 37, sir. Yes. Post of assistant professor in agricultural economics. 1 week. No. 2:30. That slot is over. It will reach. Next week it will reach. Next week, after request made by the respondent, next Tuesday. Yes. By the time you can serve copy, prepare serve copy and yes.
I appear for R2, R4.
Just 2 days time is it. This is granted. No, 2 days. 2 days accommodation. Yes, sir. Anyway, Thursday, sir. Monday without fails. Because two occasions it was listed before this. Monday to the request made by the learner council appearing for the petitioner as a last chance. This matter on Monday. Interim order granted earlier.
Obliged.
Morning, since it is opposed. Yes, sir. Yes, sir. Hollywood digging, yes, sir. Correct. $36. I think it was came up last week. Because ಈ ಖಾಲಿ ಹುದ್ದೆಗೆ ನೀರು ಸರಬರಾಜು ವಿಭಾಗಕ್ಕೆ ಸಹಾಯಕರ ರಮೇಶ್ ರವರನ್ನು ರಮೇಶ್ who is Mr. Ramesh actually? No, Edward. Or else you can reconsider it. Either you have to file, sir, either you have to file statement of objection or either to reconsider. Taking into consideration the very same, the issued by the Adalitakari Purasabha Source.
What happens?
What about the remaining, what about the remaining petitions? Who's there, sir? Or it could be even otherwise. Even otherwise, how it could be? Huh? Yes, government, we can reconsider it. See, no, what they are saying that ಖಾಲಿ ಹುದ್ದೆಗೆ ಸದರಿಯವರು ನೇಮಕವಾಗಿದ್ದರು. Take for an example. Precedence, huh? Not against a sanction. No, let's say that. Page 37. ಖಾಲಿ ಹುದ್ದೆಗೆ so and so ಸಹಾಯಕರಾಗಿ. As against a sanctioned post that you are appointed. No, it is issued by you. Not by the petitioner. It is by the your. ಕಾನೂನು ಪ್ರಕಾರ ನೀವು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು. ಕಾನೂನು ಪ್ರಕಾರ ನೀವು ಆರ್ಡರ್ ಮಾಡ್ಬೇಕು. No. ಆಡಳಿತಾಧಿಕಾರಿ ಪುರಸಭೆ KR ನಗರ. It is by yourself, sir. Maybe different. Then why has issued this? He should compensate. He should compensate the. Yeah, but for that only is they are not entitled. 64, sir. All the names of the petition are there. You can reconsider it. See, annexure C. Again, the powder DME has written to the so and so for you can reconsider. What about the next petition? No. Reconsider in the light of this aspect. I will say as against the sanction post. So please sit down, please. Yes, sir. Annexure. Yes. Annexure C. Oh, yes, this I have seen it. That is addressed by the DMA to the CMC. Oh. ವಾರ್ಷಿಕ ಭರ್ತಿಗಳನ್ನು that is by the DMA. Yes, sir. 66. Order pass.
The deputy commissioner, page 69.
Correct, 2007. Correct.
Eight of them figured in annexure series. All of them have been declared. I have pointed out. C. Ramesha is the serial number 1 in annexure C. Then G. Ramesh is the serial number 8 in annexure C.
What is annexure D actually?
Annexure D is the order of regularization.
Regularization, yes.
Two of them who figured in annexure C is they were regularized at annexure D.
Leaving out the petition.
Then
Yes, sir.
When
81, sir. ಅಷ್ಟರ ಮಟ್ಟಿಗೆ ಹರವಾಗಿರುವುದಿಲ್ಲ. It's a order passed by this court in annexure H. Yes. Whether the petition in this case is also petitioners in the writ petition? Yes.
the order differs, but they are the same thing. With the theme.
Yes.
Now, after this, what happens?
119. That's a WP number zones. Annexure P. Not the petition. Yes. Oh, they cannot, now they cannot raise this. Annexure Q.
The second convention of the government not actually second person being there, constant stays in the constant involving for very long years, continuously. One of the next, the employees do not have any real impact of it. Once it is shown that the position of the person we are
Yes.
So now the fact is either they were appointed against they were appointed as a requirement. There was a requirement. Being expected. 1999 also. People pay for equal work. This.
Yes. Yes.
Also, I passed it out. Because the employees who delivered the connection TV, they were regular. He notification.
Those were appointed and these petitions have been appointed simultaneously. Yes, sir. Correct, sir. Correct. Yes. Yes, yes, Mr. What about the second petition, sir? And the very same. Just 1 minute. Just. First petition is yes.
But still they continue to take in many institutions, contract employment basis.
Yes.
And one time measure also you don't take this kind of employment because it will reach opportunity order, but they extract work from them.
Yes. Yes. Next is. Yes. Yes, sir. Reconsideration. That you will say they have been produced records for sanctioned post. No. I will say I think these are all the records that has been produced. I will say next year insofar as B1. So that I will say. Yes, sir. Yes. Let us also dictation one date. Dictation. Next week dictation. Just I will say. By the time I will. Yes. Yes. Murne Tarik. Third for the dictation at 2:30. Yes. Next. 40s. Ankita. Yes, Mr. Ajay. Counterfile, madam. Just give me just. Not. What is the question? Yes, just.
I'm appearing for the first respondent.
On yesterday's matter. Okay. That is some question number 37.
37 minutes.
Question number 37.
Now they have changed A to C.
A or C. This is the answer A.
So someone I think he was arguing this. You have argued this. Yes. He say that see notification 1/2/22. Exam was held on 24/7/2022. Provisional was issued by R2 on 25/8/2022. So far as key answer is concerned, as per annexure A1, where is that A1? Just
A1 is at page
1 minute. 1 5 in the Which writ petition? 2185. Which
This is 8.
21? Which writ petition yesterday you argued?
1043 of 20.
10?
43, my lord. 1043 yesterday argued. Serial number.
Huh?
Question
Yes,
number
madam.
37 is concerned, my lord. 1043, my lord.
1043. And yesterday what was taken? Just give me.
The-
1043. Page 15. Just. Yes, sir. That is annexure A is A1. It is annexure A. Insofar as A2 is concerned, they say that an answer is A. This is
Answer A.
this is insofar as the key answer given by the KPTCL.
Next page.
Yes.
December 27, 2022.
Hmm.
Here, my lord says, the answer is C. That is C.
Question number 37 is a C. Ah. Yes, sir. This is Ramesh. Now, which one is correct?
Yes, sir.
Yes. No, please. Now you tell me whether annexure A is correct, annexure C is correct. But the appointing authority is the KPTC. In the event annexure A is correct, in the event if you dispute that A is not the answer, then it is a C. Then benefits shall be given to everyone. Yes. Yes, correct. Only the expert opinion has to be correct. In the event, if that means according to the expert opinion, it's a C is the answer. Then how come the KPTCL say that this answer is A?
Expert and 148.
148. 146.
Published by BT.
One minute. 146. It is by the BT Belagavi.
Reference books are there.
Bindra.
Yeah, yes, my lord.
But in law also there is Bindra.
And if your lordship sees page 148.
Law of contract.
148, question number 24.
Yes, sir.
Is identical to question number 25.
That's what, yes.
And the answer your lordship will see at page 149.
This is annexure A.
That also says
No. We are not experts. So we have to believe what the experts says. But if the appointing authority says something.
My lord, this is the appointing authority is not saying something.
But they have to work in a KPTC.
The examination.
Yes. Then what made the KPTCL to issue annexure A1? In the event if the as Ramesh pointed out, answer is annexure C. Then why did you say? Because the people they have a legitimate expectation. They have a legitimate expectation saying that what the key answer is given is correct. That is now page 15. No, sir, it is by KPTC.
My lord, the key answer is left
Now,
by
sir,
the
either A is correct or C is correct, or both are correct, not correct, or all the four are not correct. Then what will happen then? Yes. 3-2? Ah.
Because there are.
Ah. Yes. Yes. Let use. Teach. That's good. Award mass race. Take it, consider it as a COVID. Take it as a COVID. Take it as a COVID case and grind. Because see, in the event if the answer according to is annexure C, what made the KPTs also issue annexure E? A1. Yes, whether right or wrong is different, but they should not differ with you. But they differed. They say, see, take for an example question. Huh? And how come the two answers for one question? Then?
Say for example, the question should be
Absolutely.
with regard to
Sir, but you can't differ with your own answers. Once you said that C is the answer. Thereafter you said yes. No, it's not a question. If you look at A1 and as well as A2, please see. A1 and A2. That is insofar what is stated KPTCL 22. Next one is Karnataka Examinations Authority KPTCL 20. Very well. Either A1 should be correct or A2 should be correct. Then what made you to issue annexure A1? So provision cannot be wrong. Yes, very well. Yes. Yes, sir. Yes. Paragraph? Which paragraph? Paragraph? Yes, sir. Please. Yes. Yes. So 37 equivalent to 50. Let us we go to A1 and A2 in this. Just a minute. One minute, sir. Whether what is the answer in so far 50 is concerned? In annexure A1. Again A. So I will believe it. As per this para, according to the insofar as you say that the petitioner has answered A2 version in which the key answer for question number 37 answer is A. 15 allu kuda A1 allu kuda in A.
The answer is A constantly in every.
Yes. How see, sir, 37 A1 take for example. The question number 37, according to A1 is A. You say that in this written statement, insofar as just go to written statement, the set question was question number 50 in A1 version. 50. Yeah, A1. No, sir. B1 A9. Yes, yes. Yes, is A2 version. According to is A2 version. So you go to question number 50 then. One is A. That's correct. Something is missing from probably from the authors of the book. No, you go to yes, you go to statement of it. The petitioner has answered A2 version. That is A2 version. Version in which the question number 37. Yes. What you say A2, if you look at A2, question number 37 is 3. That means C. That means C. Same thing insofar as A1 is concerned. It is question number 50. It is A.
They have changed it. In A2, they have changed it fully. A1, constantly they answer A is the correct answer. At page 15, constantly they have said that A is the correct answer.
Yes, sir. Yes, please. I know. Do one thing, produce the both if you have a paper, A1 and A2. Question paper. You produce the A1 and A2 only insofar as the petition is concerned. Now the matters also. When you are. What is your 21? 21? 2185.
For the respondent.
185. It is here. It is here. Yes, what is your grievance? 1 minute. What is your grievance? Objections. Objection?
Uh,
552.
Can you be published?
Yes. Yes. It is before 29. Before 29 you filed it. Yes. Through mail. Yes. This was on 29. Yes. See, it is not yet considered. Yes. According to this, according to you, the objections raised by you has not been considered by the others.
So there we are. Question number 94. They are given option B. In the question.
90? Yesterday. Which of the following Bharata Ratna? Yes, it cannot be considered as a title. Correct.
Then
That's the correct actually. Article 17.
these errors have been option B.
What's the answer for annexure, sir? Page number in her petition. Ramesh sir. We can answer all of us. This. So it cannot be considered under Article 17 of the Constitution. It cannot be a title. I think Vijay Kumar versus Union of India, 97. It's the only case under that article. What is the key answer according to them? Oh, it's a KPTCL current. Not law. No, they are given a. No. We are all. We can answer this. 17. It should be. It should be Annexure D. It should be Annexure D. Otherwise, you have to change the Constitution of India. Otherwise, you have to change the Constitution of India. Whoever may be the expert. 79. Where is that? Page number 11. 11. 1 minute. Page.
Number 77, my lord. Read petition 77.
Yes, sir. The only person. Veto is related to. Which one is answered? Which answer is correct?
That's an absolute veto is an election.
1956. That was prior to 1956. Yes. Yes.
What is significant was asked up in there. You know,
Which one? Pepsu appropriation. Pepsu appropriation. When it was 1954, by the Parliament assented. When a bill was passed by Parliament. When it was passed by Parliament. When it was placed before the Honorable Excellency, the President, when it was given assent under Article 110, then we will see. Only 79 we will see. 79 question will take If the 77, 79, your answer will be wrong, everything will do. Because all of us know.
If you are not, they have to add it. That's the only.
Only we will, no. Only we will see question number 79. If 79, if our answer is yes, probably we doubt about our. Because the Bindra text you are referring. They have seen the Bindra book, they say that Annexure C insofar as then you are given two answers for subsequent. Some electric connection is there. Let us. That's why don't ask difficult question. Answer simple. Everyone will be know. So that answer will be unambiguous if you given, the entire selection process will go. We'll even take the titles. So all of us know Article 17. That's one. If the key answer is wrong, then I will doubt about the remaining, definitely. I think without application of mind. Otherwise, we have to change the Constitution of India. If I accept you, and that article has to be deleted from Constitution by the KPTCL. At your instance, that cannot be done. Yes. When do you? Next Tuesday. Next Tuesday. Let us also. Next Tuesday. Yes. So do one thing. You raise it for each petition. You make out a chart with keep the papers with you. Tuesday. Heard the council appealing for the parties in part list this matter on Tuesday, immediately after preliminary meeting. What period? 2:30 already. 2:30 Tuesday. That is this stayed. So that's one more submission from them.
They want to stay, it's already stayed.
Let us visit. So list on Tuesday for further reading. 2:30. By the time you can chart with papers. Yes. Yes, Mr. Correct. It has to be done within a reasonable period. When you retire. 13 39/2015. That is on you retired.
Issue on 11/20/21.
10?
11/20/21.
Okay. After 4 years. Incident
is of the year 2012, 2014. But there is a provision in the cases that which mandates that in respect your inquiry is required to initiate in respect of the incident.
4 years.
Not more than 4 years old.
Yes.
Incident is relevant, not
Retirement. So incident is after 2012 and 13. Charge more. So after 8 years. Yes, sir.
2021 not initiation. They could initiate an inquiry in respect of incident. Still not 2017.
Yes, sir. That's what I'm saying. Yes, sir. Sir, apply rule KCSR 214. Incident is of the year 2012 and 13. You issued a charge memo on 10/11 after 8 years. So both those dates are not they are confirmed. Then that is sufficient. Yes. So for us, what is challenge here? But as per 214, you cannot. No. Need not be. They will take another 100 years. They will take another 100 years. Sir, applied KCS at 214. When was the? Just show me the where is the Laka Vicharana Nadavali. 119. That is on 411.
When the initiation of inquiry itself is bad by the patient. Total of he does not write. Matrix covered by.
Sorry, settle principle. Incident where is the where is the charge memo?
Charge memo is annexed H.
Annexed H. Page.
ದೋಷಾರೋಪಣಾಪತಿ 86 10 11 20 21
You cannot.
Details of the charge at page 89 2012 page 89
Beyond 8 years.
Inquiry report holds that inquiry officer holds that charge is partly true.
So heard.
Page 113.
Heard the Lana Council appeal to the parties. In this writ petition, the petitioner is precedence is assailing order dated 4/11/2022, passed within bracket annexure N, passed by the respondent hearing, comma, seeking the recovery of 6,62,056. It is contended by Sri Satish K. and counsel appealing for the petitioner that the incident is of the year 2012 and 13, and the charge memo was issued on 10/11/2021, and in the meanwhile the petitioner was attained superannuation on 30/11/39/2015. Accordingly, in view of the provision under Rule 214 of the Karnataka 1B.
Adopted by the corporate.
Yes, yes. Yes, yes, yes. Amen.
Paragraph 295A.
Yes. Accordingly, it is 10 units. 214 of ACSR accordingly sought for interference of this court. He also refers to the order dated notification dated 25/6/2021, whereby the respondent have adopted the provisions under the provisions 95-A provisions similar to the provisions under Rule 214 of the KCSR listed. In this connection, we refer to Rule 95 -A of the KLAC Cadre and Rules 1996 and submitted that, the initiation of the proceedings against the petitioner itself is contrary to the rules governing the field as well as the initiation of the inquiry ought to have been made within a reasonable period, and therefore it contended that the impugned order is liable to be set aside. Per contra, Mr. So-and-so and a counsel appearing for the respondent contended that though the incident is of the year 2012-13, however, due to the interim order passed by this court in which WP? In WP number 3872/3 of 2018. Even otherwise more than 4 years. 2018 ಅಂದ್ರೆ 2012 ಅನ್ನ 2016 ಒಳಗಡೆ ಇದ್ದಿದ್ರಾಗಿತ್ತು. 2000 then it cannot be now. Then 3872/3 of 2018, the respondent authorities have not able to initiate inquiry against the petition. In the light of the submission made by the Lana Council appearing for the parties and taking into consideration the incident is of the relevant incident alleged against the petitioner is of the year 2012-13 and the charge memo was issued on 10/11/2021. The respondent authorities have not initiated inquiry within a reasonable period and that apart, the petitioner has attained the age of superannuation on 39/2015. You have to view that the petitioners have made out a case for setting aside the impugned order dated 4/11/2022 within bracket annexure N passed by the respondent insofar as the petitioner is concerned. Accordingly, writ petition is signed. The remaining matters will be taken up some other day. Next week. Any 132 ನಲ್ಲೆಲ್ಲ ಏನ್ ಮಾಡಕ್ಕೆ ಒಳ್ಳೇದು, ದೇವ್ರು ಒಳ್ಳೇದು ಮಾಡಿ. Next, ಯಾವ್ದು ಕೊಡುವ? So remaining matters, insofar B group is concerned, it may be taken.
45, my lord, 45. 45, my lord, he is dismissed from service, my lord.
Yes.
45, a date may be given.
Yes, sir. Insofar as
Without furnishing copy of the inquiry report.
Next two state will be taken up. So two state
Yes,
will reach. No. Afternoon we have 6-7 matters now. Tuesday it will be. Tomorrow it may not. It's not possible. So equality. B group matters next Tuesday. Let us listen. Remaining matters finally. Yes. So it will be taken up for Tuesday. Let us listen. What will happen? What is a prayer? What is a prayer? Yes. So tomorrow, let us listen. Tomorrow, let it be there like this. No, let it be there. Let it be there. Will reach. Yes.
Court officer, madam. Court officer, madam. Court officer, madam. Court officer, madam. Hello, court officer, madam. Hello, court officer, madam. Court mute ಆಗಿದೆ.
Yeah. Sir. 52, yes, sir. 53, sir. 53. 2020 matters. Even 2015 other pioneering latest. Yes, sir. Outside area. Yes, sir. It's order passed by the aided institution. It is not 131. That's the law. You know very well also. See, someone is as a legal senior counsel. We have to look into the book and we have to say. Senior counsel is even otherwise, if it is appealable order, it has to be. No, no. How do you know? How do you? Then, sir? That's what I've seen. No, no. Yesterday, that I've seen. That's a revision. Revision lies. It's an order passed by the court. Even writ petition cannot be accepted. No, no. Don't delay the petitioner to give review. Today is a good day for us. No, no. Sir, even if you engage in a senior counsel, you cannot change the book. See, that's the law actually. That is the law on the point you are aware. You are also aware. I told you to read also actually. No, no. Sir, I told you to read provision. Nothing. See, even read, how can it college will, how can the order will be passed against a college? Even take for an example. You tell me, how can I issue to the college? See, that cannot be done actually. That's why what I'm saying, you go before a revision, I think at the earliest, so that whatever is period spent before this court will be condoned. That is better. So that is a law on the point. Sir, even otherwise, sir, even if any senior counsel, you can change Karnataka Education Act only by the legislature. Only Karnataka legislature can change that. No judge. That's law on the point. We will go third. That's why I asked you to read it. Third, the Nana Council appeal for the purpose. Yes, very. Yes, yes. Third, the Nana Council appeal for it. In this writ petition, please don't. In this writ petition, the petitioner is questioning the order of appointment dated 9/7/2021 issued by the fifth respondent institution. Fifth respondent institution. Within bracket, annexure L. Insofar as the post of assistant professor in chemistry. Assistant professor in chemistry. Mr. Satish, Lana counsel appearing for the respondent, raise primary objection relating to the maintainability of the petition, contending that the fifth respondent is a aided institution, and therefore the petitioner is having an alternative remedy under Karnataka Education Act 1983. This said submission was also endorsed by Leonard AGA. Sri Raghavendra the counsel appeared for the petition, contended that the writ petition is maintainable insofar as the order passed by the fifth respondent institution, and the matter is pertaining to the appointment to the post of assistant professor in chemistry. Having taken note of the factual aspects on record, comma, and it is not in dispute that the impugned notification dated 9/7/2021 within bracket annexure L is issued by the respondent institution. I must do that, comma, the petitioner be relegated to approach the competent authority under the provisions of the Karnataka Education Act 1983, comma, full stop. It is also full stop. Accordingly, that petition is disposed of, directing the petitioner to exhaust the efficacious remedy provided under the aforementioned act. Needless to say that in the event the petitioner approach the competent authority under the above act, comma, the respondent authority shall waive the period spent by the petitioner before this court. With these observations, writ petition disposed. That's the law. First, you have to file it. It has to come before a court. Then they have to look into it. Interim order granted by this in order to enable next after disposal of the writ petition, Shri K. Raghavendra Lana counsel appearing for the petitioner contended that the interim order granted by this court shall be extended till it shall be extended. However, the said submission was opposed by the Lana counsel appearing for the respondent. In the ends of justice, comma, the interim order granted by this court shall endure to the benefit of the petitioner for 4 weeks from today to enable the petitioner to approach a competent authority under the above act. Yes, sir. Same. There also, I think. Just a minute. Put it in. See, next petition. Send it. Okay. Who has passed the order? No order. Mandamus against the respondent to assign the work to the petition. Directing the that is it. Just a minute. Directing the respondent for pay arrears of salary with all benefits. Where you have stated in the where you stated that maternity benefit has not been extended. Can make a claim. No. In the annexures, you have to make a claim. Where you have made. In the event of that, they have not connection. Which one has to? Yes. Q. Just a minute. Yes, sir. No. Okay. Just 1 minute. You can take decision in so far as this. Really? No. They sought for the benefit under the act. Maternity. You can take decision. Either you can grant or you can refuse. Either way you can do that. At least then, because you said 28/5/2020 representation, you take decision in the matter. The petitioner hearing contended that the petitioner has not been granted benefit or act criminal, benefit under act criminal, benefit under the provisions of so and so act, maternity so and so act. Without expressing any opinion on the merits of the case, respondent institution is directed to consider the representation dated 28/5/2020 within bracket annexure Q in accordance with law, within outer limit of 8 weeks from the receipt of this order. Let us listen. Yes, sir. Yes, sir. What is challenge, sir? The suspension order. Yes, sir. Let the notice shall go. Let us. Let the notice shall.
We of course will be normal. And there after taking into consideration of the matter, the learned has ordered to complete the inquiry within 3 months.
Yes, where is that order?
It is at
41 page. Yes, next. Yes, sir. Page 41. Yes, sir.
The inquiry officer is completed his inquiry.
Correct.
And a report to the respondent saying that there is no such charges have been proved by the PBC and the reported to the respondent number 1.
Yes, sir.
Despite this name, the respondent number 2, being a deputy commissioner having no such authority, that part of the suspension order.
Where is that?
That is a annexure here. The other end,
Where?
to subsequent to the receipt of the said inquiry report,
Yes.
against the corporation.
Yes.
Yes, there was no such occasion to suspend this.
Yes, sir.
That to say that it was not charged at all.
Yes, sir.
They never reported importance.
Let the other side will appear.
And on the other hand, the section 84 of the respondent number 1 is authority. The only authority to suspend retirement or whatever.
Your group C or group B? Group C. Group C means the BBMP. Group C means the BBMP only. He is the authority. It's the BBMP only. Group C is the BBMP only. Group C is BBMP only.
No. If they notified as per section 82, there are specific posts they have to be appointed by the government.
Yes.
Get your post as per section 84, the commissioner is the appointing authority.
Yes, sir.
He is the only authority to issue suspension order or dismissal order as per section 90.
Let the notice shall go.
1 year is not.
You sir, copy to the others.
Here not getting the charge on the other hand, the interim order to the operator
Suspension. Suspension order cannot be interfered. Yes, sir. Issue notice, let the other side will appear. The suspension order cannot be interfered. Only after hearing the other side, I can take.
Authority of law must.
Yes. In so far group C, So the group C is considered the BBMP is the competent authority. Group C is considered BBMP is not the government.
First day ಹೇಳಿದ್ದಾರೆ. Look into that. Section 82, 83, 84 and who are all comes under those.
Correct. Correct.
Kindly notice that appointment of engineer, health officer, etc. So those officer has to be appointed by the government, and hence government is the appointing authority.
Yes, sir.
As per section 84, kindly notice that appointment to the other posts under corporation establishment. So subject to the provisions of section 85 and 86, appointment to post of the.
You say FDA, sir. You say FDA, only the BBMP is there. In the BBMP.
Yes, yeah. The structure is the appointing.
Let the other side. Let the other side will appear. Let us.
The particular section 90 ಇದೆ. ಯಾರು ನನ್ನನ್ನ ಸಸ್ಪೆಂಡ್ ಮಾಡಬಹುದು.
You say that. Let the others will say whether it's competent or not.
My sense. Provided that no such officer or other on verified as aforesaid shall be reduced in rank, compulsory retired, removed or dismissed by any authority subordinate to that by which he was appointed.
Correct.
So the person who appointed the employee is the only authority to remove.
That's the law. That is the law. Whether it. Yes. Let us let the other side will appear. Suspension cannot be, sir. There are 3 types of suspension. That's what I'm saying. That's what I'm about to say. So Leonard M.A. Subramani, except notice for respondents BBMP and a council applying for a petition is permitted to serve 2 sets of the copy to the Lana council representing the respondent. This matter next week. Next week. 4th, sir. Ready then. Yes, sir. Not against the sanctioned post. But yes. But it's not against the sanctioned post, sir. It's sorry. Judgment. Yes. Only thing is, you are not established that you are not in against the sanctioned post. Not vacancies there. You have been appointed as against that post. You have been appointed as against that post. What do you mean? Not against that post. Yes, sir. Yes, sir. That was argued actually. Yes, sir, that I have seen it. Maybe true, but it's by the But that order should have been endorsed by the DMA. It's not- And it has to be approved by the deputy commissioner later. That was not done actually. That was not done actually. Only within the paragraph of 53 of Umadevi. Only thing is not against a sanctioned post. No, that's right. I've seen Umadevi matter. Told. It will be only against a sanctioned post. Section 50, paragraph 53. There are 4 ingredients that you have to fill up. That has not been done. No. There's no sanction post. Only. Yes. Yes. Vacant was there. You have been appointed as a, that post is not there. That cannot be done. I've seen page 28. You are ready. That's what I've read it. That I've read it. Even if the appointment is made, even by take for an example, CMC Asan, that's approved by the deputy commission, thereafter the DMA. They have no authority actually. I know. Not necessary. That's a constitution bench judgment. We are bound by that. The later one, only the later judgments on the regulations is only tinkering. That's all. Just I read it. All 4 ingredients. No. That has to be applied. I've read it. It's not considered unless you have to establish that cannot sanction post that cannot. And that has to be approved by the higher authority also. Not necessarily that it should be. No, vacancy is there. You have been appointed to that vacant. That is not there. That's what the impugned order as well as the. In the event if you have been appointed to that post, then there will be a regular appointment. They have to notify. Then regular appointment. Continue. No, not a case. Not a case. Yeah, that's what that also I have seen. 1990 order. 1990. Annexure A, 20th November 1990 order. I'm sorry. Page 1989, 89. Now Umadevi judgment. Not a case. Not a case to interview. Reject. Not permissible within the framework of law. No, that cannot be considered. Fails. Yes. Not a case for interim. Sorry, sir. 59 to. Not a case for that. Sorry. 59.
Yeah. Take on it.
That I've seen, even latest. Social justice illa. To rule, see the rule and pass order. That cannot be done. Only Uma Devi judgment has to be looked into. Only 5 judges bench means another 5 judges bench has to say, not below that. 59, yes. Yes, madam. You are supposed to file. Yes. Yes, madam. You are holding you are filing affidavit. Yes, sir. You sir, copy to the others. Have you sir copy to the others? Six, madam. That I was a community officer and I was not a chief chief officer. As per this, I was not working as in charge officer at that point of time. I worked as a chief officer only from 2015 to 18. You can just you verify. Let you will verify your affidavit. No, let you will verify your with the respondent. Who appears for the just to verify, sir. Then a counsel appearing for the petitioner, filed affidavit in terms of the order dated 20th June 2023. Learned AG is directed to verify this. Yes, next week. Next week again. Next week, the same. 2:30. At 2:30. Yes. Verify, sir, whether he was working as in charge officer or yes. 56.
Further hearing matter, serial number 56.
Mr. Vijay Kumar, sir, I think probably it may not be possible today. I don't want to make you to wait actually. '56. I know. No, that right. 57 so that I can complete today. Requires considerable length. In a day. On Monday and another one is Tuesday. Monday one matter, you have 2 matters today. 2:30. 60 and 62 also your son.
Yes.
Okay. Only there. 62 and 61. Either one day, Sunday one day I will take it out. Another day I will take it. Tuesday. Monday, serial number 60, Monday. Then same day, let us will see 62. Same day, let it be there. Let it be there. Because already we have one matter on that day. We try to accommodate. Because today their matter, 4 to 5 councils are there. Monday, 15 days. I know. The law officer. 2 weeks. 2 weeks, let us go. Stop at 2 weeks. Date better than just. Yes, sir. No, let us, I will pass it over for a minute. Let the 57 will be taken up. So that at least one petition will be closed. Yes. Yes, sir. Yeah, that you have. That's correct. Yes, it's better. 57? If other council are there, I can hear them. Just that's. 57.4. Mr. Prashant. Yes, Mr. Prashant. You say that the issue involved in other petition. Huh? So according to you, it is. Yes. No, the way-
Serious position has been taken, stating that when we hold the past resolution, it was sent to the government for approval. How that even after the 15 years of the service in the board.
Yes.
The approval of the state government is not getting as of today.
Let us will take 57 onwards. Yes, sir. I think I have heard you. I think that I made. Good evening. Notes.
That's what I.
Yes, sir. Yes, sir. That's out. Only except. Yes, sir. Yes, sir. That also better. Yes, sir, very well, sir. Yes, that is integration of quota. So he has been. Yes. Very well. And Annexure G was amended. That is amended. 6/10/2016. Change. Yes, sir. Yes, sir. What do you mean first? Yes. Correct, sir. Yes. Director recruitment is 34/19.
Very much served as a speaker.
Yes.
4 years service after graduation.
Yes. Yes.
Yeah, good.
Yes. Yes, sir.
Private graduate.
Paragraph 34. Yes. 7 years experience of service as a deputy. Yes, sir. Yes. Yes. Yes, sir. Correct.
They cannot prepare one separate list.
Para 7 in the division bench order. I got it, sir, so that others can compete.
They apply reservation. Operating in order of motion, and not doing it double. Assistant engineer graduate for them. Assistant engineer non-graduate for them. Assistant executive engineer graduate for them. Assistant executive non-graduate. If it is consolidated, right? 14 plus 3 plus 15 plus 3. That is 0.24.
Okay, yes.
38. Become double. They do it.
Yes. Yes, sir, that's. Who else in WP number 502652? Sanjeev, Jagdish. Yes, sir, Jagdish. You want to say? Yes, they have. Authority has to say. That's correct. Yes, sir. Yes, sir. Your petitions. 57.2. 1 minute. I think except that, I think all the petitions have been heard. Prashant has been heard. So what will happen in every matter, assistant engineers, executive engineer, every day. Sahasranama iddage. Every matter, assistant engineer or junior engineer, either KPTCL or corporation like this. That's why facts will be dictated on the very same day. Engineers. Yes. Yes. Prashant has right. Compassionate appointments. Meter readers. Meter readers that you are referred to. Yes, sir. That will. Yes, sir. Yes, sir. Will. Except serial number 57, no other matters. Not 58 is it? 56. Let it be 56 will be. Okay. It's very difficult. It takes. Tuesday it will be. Tuesday at 2:30. Yes, sir. So that only this matter could be heard. What is the challenge, sir? Much N and P. This the notification dated 14/8. Yes. 122. SV Venkateshwara.
Devraj is respondent number 3. Rajiv is respondent number 2. Parmesh is respondent number 5. Ramesh is respondent number 5.
Yes.
As far as the petitioners are concerned, period number 149, Rangaswamy, period number 150, Kumar Nayak, and 151, Maran Jayashankar.
Now, according to they have been pushed back.
And case is all the three petitioners have to go after court. That's how the seniority is.
On what? Yes. What's it?
Making others subject seniority. One for the graduate and another for the contract.
Correct.
And as far as that is that I am speaking, almost all the petitions have registered to get that. That's the main vein of argument. As far as
Yes.
they have consolidated seniors.
Yes. Yes. According to you, two lists could not have been made. Yes.
One belongs
Yes.
on basically available
Sorry, one. Sorry. Yes, sir. Yes, date of appointment.
Rangaswamy and Jayashankar. They are all appointed as junior.
8884. Yes.
They are all just taking the promotion. The next category of assistant engineer. Now 28 by 98, 28 by 98, and 1698. Which is on which the petitioners matter, you get assistant engineer. Respondent number 2 date may receive, it is 26 and 1990. So when these three petitioners became assistant engineers, none of the respondents here had even entered the category. So all the other dates are subsequent to 28 by 98 in 1619.
Yes.
So apparently, as of the day, I was promoted as a and my appreciation as a proposed to be a
Correct.
the next promotional avenue is as an assistant.
Yes.
Petitioner number 1 and 2 have been promulgated on 8/3/2006. Petitioner number 3 on 27/3. All of this on 27/10/2007. So having regard to that fact, Kumar Nayak and Rangaswamy became assistant executive engineer even much prior to the rest of the petitioner number 3 on 27/10. Then executive engineer. 1/3/2016 is the date as far as petitioner number 1, 2, 3, respondent number 2 and 3. And the rest of them have come as executive engineer. This is additional. The relevant dates, if it could be seen. Also, right from the joining of the service, promoting the
You are the senior most. When executive engineer is concerned, you become
on the same day they are promoted. 1/3/2000. Page number 3.
Yes.
Made a position as to where the various seniority lists that had been published.
So every year.
Commences from 1/4/2008 till 1/4/2006 that have been published. None of these seniority lists have been found. For which 3 entries are of petitions, Kumar Nayak and Rangaswamy.
Correct.
Also, 2008 is not going to see. The entry is 64 and 8 as per the petition. This temptation is responding number 2 in your petition comes above Jayashankar in this declaration. Then all the rest of the so
Petitioner number 1 and 2 are online. In the middle minor, they are Venkatesh Gupta. And then Jaishankar comes and the rest follows. This was the position minor. Bro,
Yes.
has been how
Yes.
this minor various that I have right. Is part of the also and also is not document.
Yes.
This position minor would clearly make it. One challenge. Their minor for because this was like before. So what stood as a position right from the year 2008, first time it has been changed in the year 2008. That's this. And minor it is also justified because of paper that I got from my work. But all along that has been
Yes.
in that view of the matter, as far as election has to go because we prepare and consolidate.
Yes.
As far as annexure N is concerned, this is an important material with that. So all along keeping me as a senior and now under this, not. This is my basis. This is that matter I have made a compilation of this. The defense judgment is non-class judgment matter which has been cited always. One paragraph matter that I would like to.
Para?
Para 6 page number 7.
Yeah.
But this point that will be a single senior.
Yes, yes.
We do not burden our judgment with case. It is well said that 2 or more persons are appointed to a head by way of promotion. Same interstate seniority of the promoted is promoted cap. To determine the difference in length of service, I each of the promotion. So applying the ratio manner to my case. Even when I became an executive engineer, I shared the data promotion.
So yours is the length of services.
Length of service. And even when I share the dates, I would the same date with the other respondent. That's why the executive. And in regard to the length of service that I have put in, and it's always been
Yes.
Few judgments that I have relied on. One is one is the judgment in KR Mundal versus Afi. Vijay Kumar Kaur versus India. These two judgments I am relying on the point of India. What I am making a submission is, seniority is also for past 11 to 12 years substitute minor in that. And I have this thing. No challenge whatsoever. In that view of the matter, what the honorable other taking the 10 paragraph number 2.
Yes. It has to be. It has to be.
In a reasonable thing, it has to be done. We also see what all is equated for. Depending on
Yes.
Vijay Kumar Kaur versus Vijay on the same. That is like the honorable effect of
Para? Paris. Yes. Yes.
From the opposite to
Yes.
But it is a reasonable plan. If it is then during the insurance market, but the education. An obligation or declaring on the ground of against in the matter of great significance that at one point of time, it is there on many things to total insignificant. We take it out of it. So any case matter of a quota or anything that has been writing, all the parents have been done in a long time that have that.
Yes.
What judgment commission
Page number 22. Amarjit Singh versus Devi Ratan Tech.
Yes.
Page number 71 may be. Paragraph number 20.
Yes. Definitely.
In the recent case, the motion has been made by the people on 19%. We will do one. Both had made promotions in the different rating. And the promotions had been made in retrospective effect with different dates. In the repetition before the High Court, the promotion of the appellant had not been under challenge. The seniority which is consequential to the promotion could not be challenged without challenging the promotion. Challenging the consequential order without challenging the case is not allowed. But I am relying on this reason because this is really my promotion. The issue of the matter, my lord, having regard to the promotion that has been given, and I am already seeking service. Then you put me down, my lord, is not so. This is the proposed point, my lord. Last judgment to be even those of my lord coming to take it. But I am relying on this judgment because of the interpretation that was possibly made. As whether 4 years of for a person who has acquired this degree.
Yes.
There are 3 relevant dates already found without before taking the relevant judgments, 2 relevant dates. Is the date of graduation. First petitioner by name Kumar Nayak became a graduate mother in the month of January 2005. The month of November 2013. So, petitioner number 190 is year 2005. Now, my lord, the date would now, my lord, can kindly take the start.
Yes. Correct.
He probably is on 1,2015. So we had served, my lord, even that 4 years if it has to be taken in any event. By the year 2005, we had already become graduates. And we had 15 service, my lord, of nearly 10 years having taken the graduation. So that interpretation as to whether the educational qualification is the date of recording of the educational qualification. As far as petition number 1 can be significant. Because in any event, my lord, they have passed 4 years anyway.
Yes.
But that could be relevant only as far as for that one line of argument of mine, this promotion has never been challenged in India has been worth. Second point, Manager, that I would like to say on the element of people.
Yes.
How the honorable of to that page number 34, my paragraph number 5. It appears, Manager, is how it begins.
Yes.
It appears to us that state government is laboring under a wrong resolution and the applicability of past as indicated in regulation. This court defense petition has only indicated past practice should not be upset, provided such practice conforms to the for promoting intention for some time past. The rule has made applicable in a particular manner. In our view, the decision in Nathan's case only indicates that past practice must be referable to the applicability of it by interpreting it in a particular manner, consistently for something. Any past practice divorced the rule cannot be taken into consideration as past practice. Consistently for long by interpreting the rule. It may be indicated here that a similar person also came for consideration before this court. In NBUC in Mississippi, again, the decision in duration of the it was indicated that when the language of the rule is quite specific, that if a particular length of service is either the educational qualification enable a candidate to be considered for promotion, it will not be proper to only experience
definition of period. Because such interpretation is needed the very purpose to be recently to the end of to acquire. So it is not after completion of 4 years, after completion of after attaining the education qualification that 4 years time after. Now the way it has to be understood as per this judgment. Okay, that will not be proper to show the experience only from the date of acquisition of experience. But second,
Very purpose to give it. So everyone will acquire after joining the club.
the language of the rule model eventually. By the time they become the assistant. Number one, without any room for interpretation, submission is transferred. Judgment must have been made. This is communication page.
Yes.
This one was kindly take. Page number 28, communication to paragraph number
10. Yes.
It is on this matter, the High Court. The High Court held in favor of Promotional by allowing the justification by relying on the judgment these people Joseph, which is in this regard, the judgment in eligibility was also relied upon by the judge, which had been cited in these people Joseph case, all the aspects of education service. The case point that when a rule is quite specific, it would not be proper to move the experience only from the date of educational qualification. Because such an interpretation will violate the purpose of incentivize the employee to acquire higher education. The relevant past practice followed by the department leads to the same effect. The practice of considering the delivery of a junior engineer as a whole was said to have acquired status as the rule of law. Simultaneously, it was also observed that since the very rule in question at an institute in this court was not open for CH to have relied upon decision for some other rules. In the context of the two judgments of the Supreme Court so discussed, was observed that Children's Dunya and others, the legally later judgment of previous had distinguished itself from the earlier judgment in these two laws. Being the judgment of two judges on the true interpretation of certain. The aforesaid resulted in the specific division being filed. Initial proceedings. The two judges bench of this court, in terms of the order dated 31/2008, referred the issue to be considered by the larger. By making the reference, the two judges bench opined that these people Joseph case apparently was not reflecting the correct position, correct agreement, as by something almost identical. A larger sense of judges had opined. The contrary in the Dunya and others case, as also in JK and others, but the Rajasthan Housing Court and another. Where this court had opined that the period of experience must be reckoned from the date of distribution of the degree. This is how the matter came up before the judges said, as now constituted for our consideration. Paragraph number 14, the contention.
So this is a reference. 20? Yes. What was held? What was held? There's no distinction between the time periods or before or after the acquisition. Paragraph 26.
The view of the opposite, the upward, the view taken by the High Court finding that there is no distinction between the time period before or after acquisition. So long as the degree is acquired and it is the basis for consideration of
That means the date on which acquisition of the particular degree, particular education.
Ultimately, I must have the degree by the time I must go to the career. Now, recording 4 years from then is not known. Now, as on the day I was appointed as an executive engineer, I had put in the civil service as an assistant engineer and even also had it. And then in the two of the matter, then we all learned the all the state money will become. That is the judgment manner. And the last judgment manner that I am citing, of course, is part of the reputation that I am. If they are all interpoints, the petitioner in 502
They had challenged, the challenge. So far as giving the benefit to don't take up the responding number 2 there.
Yes.
This one of the four ultimately applied the articles. Said that he did have 4 years of, he did have the degree qualification in also had completed degree in study.
Yes.
And hence one of the challenge was done. This is not that's not for the
Correct.
of course, they have relied on, made a fair mention. They have suffered this order. So now it is not for them. Come again and say that they have to regard to the charge Manatharan. That is named the entire case Manatharan.
Very.
There is an act of a counter money to 50365.
50? 50?
That would be kind of the prayers that have been made. Because I am a respondent to incentive.
Correct.
I have been added as respondent number 4 to 6.
Yes, yes. Yes.
Then now that is where the prayer that has been sorted. An integrated gradation list have to be prepared. That with
First petition.
report
First
have to be looked into.
5026. Yes.
Now, what was not at all being urged at any point of time till now, for the first time around my parents intentions have been taken up. To accept my CV.
Yes. What about in 5065, 50265? In that you are the respondent.
I am responding. Please see the kind of release manner that happens. That is where it is got up. This number 32 manner that we prayer has been made. But the relation is got to be done.
Yes.
And then manner the prayer is
Executive engineer.
yes, then they have the relationship manner that they see to done.
Yes.
Then they see the mandamus that there must be an integrated relationship of education, their graduates in non-form. As per the specific quota.
Yes.
They think the respondent number 3 is philosophy. So much of water has been involved. Appreciation can continue to grow. And eventual picture is my Lord says.
In the event if the relief is granted in this petition, so
I will push down.
push down.
And this quota and government that they are seeking to be worked out. It's after such a long lapse of time. Right from the year 2008, when they consolidated graduates having published from time.
You're saying that they are well aware about this.
And this was never challenged. And promotions are not challenged. And eventual picture was if I could not notice. Of the tabulation is not.
Yes.
Ultimately, they became chief engineers on 37.
Yes.
Almost all of them.
Yes.
So these are the things that we have been decided. In 5025. It has got no much of a consequence as far as that. Now, at this point of time, you go back 15 years from now, and then to upset the whole thing on the basis that there is a violation.
Yes.
But even that exercise at this point of time will not be considered.
Yes. Yes. Anybody else? Yes. Board. What is this? Sorry. Let us will see. Let us will see. We finished up. Later. No. They will. Let the respondents will finish up. I know. In his your yes. Let it will be reserved. Your arguments will be reserved for some time. Yes. What about in 50? No. I want to know 50265.
5065.
Respond number 2. Yes. 502. Yes. Your objections. No, in objection. Yes, sir. Page. Okay, statement. 1 minute. Respondent number. Oh. Yes. 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 That is as per 2009 senior. Yes. Yes.
My ranking was this all the. You got to say it is dinner. I think you remember that. 3 occasions. I tried them all.
Yes. 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 Or one? Yes, yes. Document number 1. Document number 1. Yes. Yes. Within the reasonable period, it is. Yes. Anyone in respondent? Yes. For the boards. Yes, sir. You should. That's why you should have been the real opponent for the petitions. Yes. Yes. When you argue, I think again, see what will happen every day. I told you now. 3 to 4 repetition assistant engineer, executive engineer, junior engineer, either KPTCL, PWD, or something else. So then it's very difficult. Huh? Once it is taken up, it has to be finished and at least thorough with the facts. Otherwise, it is very difficult. Otherwise, if you ask me any day after 4 weeks, 5 weeks, I will grant you no problem. But once it is taken up, it has to be finished. Otherwise, what will happen? See, yesterday, entire afternoon, assistant engineer, executive engineer. So that is there in my mind. See, one more, this assistant engineer executive. Tomorrow another guy from corporation. Another, tomorrow all is going. So it's very difficult. Actually. Anybody for respondent in this?
My lords, for respondent number 3 in writ petition 50265.
Yes, sir.
My lords, I don't want to trouble your lordships by going through the same
Statement of
arguments. My lords,
objection
I
is
adopt-
yes. Yes.
Please, my lords, I adopt the submissions made by my learned senior friends, my lords. Only point that I want to bring to your lordship's notice is that respondent number 3, my lords, has retired on 31st September 2021.
Yes.
More so, my lords, he belongs to the ST category. And my lords, pursuant to BK Pavitra 1, he was demoted, and after BK Pavitra 2, which is the act, he was restored back to the position, and he retired as chief engineer, my lords. That's the
When
only
he
point I
retired?
wanted.
When he retired?
31st September 2021, my lords.
September 31/9/21.
Please, my lords.
Yes. Yes. Very good.
That's the only point. Grateful. my lords.
Anyone for the respondent? 9-3? Yes. Yes. Anything else? Yes, sir. Yes. That is 57.4. 57.4. Yes, Mr. Vinay. That's 2280. It will be dealings.
Because the respondents here, you know, they are the existence.
Otherwise, if it is a same set of facts, it is dealing. Yep. Now you are appealing for the petition. This, I think 57.5. I think you are for the respondent, sir. Then you have to take notices so that that I finished. That's yes. So far as I will dealing it, and it may be. Yeah. Because there it is so far as the qualification and it's integrated or not. That is not there in your case. That was not the case here. Third. Okay. 57.4. But the notice shall complete that. Yes, Mr. Vinayak, for whom that you are appearing? 57.4. Sri Vinayak. Initial is Vinayak B. Accept notice submitted that on instruction that is appearing on behalf of respondent number 4 to 6. Registry is directed to print the name of Sri B. Vinayak for the respondent number 4 to 6. Bill Sanjeev accept notice for respondent number 1 and 3. Leonard AGF for the respondent number 2. That we will delink it better. In the event, otherwise thereafter we can adopt a very safe judgment for you. In the event if such be the case, delink 22803, dealing from the WP number 50265 of 2009. Yes. In which 4453. Yes. That could be allowed. Even that could. Yes. That could be allowed. Yes. Yes, Prashant. That could be allowed. Only the fresh seniority list has been challenged by him. 57.1 ali. It is submitted that the copy of the IA number 1/23 served on the respondents. Heard the Lana Council appealing for the petitioners on for the parties on IA 1/23 full stop. Taking into account the amendments made in the IA number 1/23, the same is allowed. Then a council appealing for the petition is permitted to file the amended petition. Yes. J. Prashant is 8, 9, 10. Any other respondents so that they can? Yes, sir. When do you want? Monday. No, that will also 22802. 1 date. Let it be there 1 date. 22803 next one date. Any date. Any date. Is this matter in yes, sir? That the notice will they will file. The event if considered, then I will. Yes. Let us. It's Monday, Tuesday, 4 matters each. Judicial officers. That's correct. No. 6. 20. The 6th after preliminary. Seated that it will be finished either way. 6th is morning, sir. Not afternoon. Afternoon RSA matter, sir. List on 6th for further hearing. So on. Very same. 22802 of 20. List on so and so interim order granted earlier action till next. Wherever the interim order is there, it will be extended. Officer, it cannot be done. This from partner. Can argue so that if you are ready, I can. Yes, please do. At least one petition will do. Yes. Good. Regular vision. Babura. Yes, sir. Yes. Yes, sir. Till then, we will argue. Again, answer. Probably must have a good case on merits. Busy, I know. Where is he now? Where is he now? Hey, Nasser. Where is that? I know. Anyway, you argued, I will. Nothing to do. Any other day? After 2 weeks ಕೊಡಿ. ಮಧ್ಯ ಆಗೋದೇ ಇಲ್ಲ. 11th, 11 July. Let us fix. No. Dictation ಇದೆ. ಇವಾಗ ಗೊತ್ತಲ್ಲ. ಅದ್ರ ಬೇಕಾದ್ರೆ. Starting from ಇವಾಗಿತ್ತಲ್ಲ ಅದೇ ಮ್ಯಾಟರ್. ಫಸ್ಟ್ ಮ್ಯಾಟರ್. ಅಲ್ಲೇ ಮಾಡ್ತೀವಿ. ಅಲ್ಲೇ ಕಳಿಸ್ಬೇಕು. ತೊಂದ್ರೆ ಇಲ್ಲ. ಎಲ್ಲ ಸಾರ್ಟ್ ಔಟ್ ಮಾಡ್ಬಿಡಿ. ಸಿನಾಪ್ಸಿಸ್ ಏನೇನ್ ಬರ್ದಿದ್ದಾರೆ ಅದೆಲ್ಲ ನಮಗೆ ಸೈಟೇಷನ್ಸ್. ಅದರ 5 petitions.